Our mission is to empower Indian citizens by sharing knowledge about their fundamental rights as specified in the Constitution of India. If you are watching us for the first time, don't forget to subscribe and click the bell icon, select all so you receive notification whenever we upload new videos or go live. Sharing this video with your contacts would be greatly appreciated. आदाब, नमस्कार, सत श्री अकाल दोस्तों, आप सभी का स्वागत है सिटीजन जस्टिस फोरम के इस वीडियो चैनल पर। हमारा मिशन भारतीय नागरिकों को उनके अधिकारों के बारे में जागरूक करना है जो भारतीय संविधान ने उनको दिए है। अगर आप हमारे चैनल पर पहली बार आए हो तो सब्सक्राइब कीजिए और बेल आइकन को क्लिक करके सब कुछ चुनें ताकि जब भी हम नए वीडियो अपलोड करते हैं या ऑनलाइन जाते हैं तो आपको उसकी सूचनाएं मिलती रहे। और हमें बहुत प्रसन्नता होगी अगर आप हमारे ये वीडियो आपके दोस्तों और संपर्क के साथ में साझा करेंगे। और आज की जो टॉपिक है वो बहुत चर्चित टॉपिक है 65B के पहले एडवोकेट महेश वासवानी के भी 65B के हम लोग ने वीडियो अपलोड किए थे जिसको भी बहुत लोगों ने व्यू किया और शेयर किया और रवि जाधव ने भी 65B के बारे में बात किया। तो आज हम जो बात करेंगे वो सुप्रीम कोर्ट के एक जजमेंट के बारे में बात है जो 65B का सर्टिफिकेट हम ट्रायल के किसी भी वक्त में लेके आ सकते हैं उसका खुलासा किया है। तो आइए चलते हैं। द सुप्रीम कोर्ट reiterated that a certificate under section 65B of the Indian Evidence Act to prove electronic evidence can be produced at any stage of trial. A bench comprising Justice Vikram Nath and Rajesh Bindal set aside the judgment of the Karnataka High Court which refused to allow the prosecution to produce Section 65B certificate in a trial relating to the 2008 Bangalore blast case. The bench referred to the 2020 judgment of the Supreme Court in Arjun Pandit Rao Kolkar versus Kailash Bhushan Rao Kotyal, which held that the certificate under 65B of the Act can be produced at any stage if the trial is not over. The court also took the note of the observation in the 2014 decision of Anwar PV versus PK Bashir that a certificate under section 65B of the Act is not required if the electronic record is used as a primary evidence. And reference was also made to the 2019 decision of the state of Karnataka versus MR Hiremat, which held that the non-production of the certificate under section 65 of the Act is curable defect. The case related to the bomb blast which took place in Bangalore in July 2008 which claimed the life of one woman and left many injured. During the investigation, certain electronic evidence such as one laptop, one external hard disk, 3 pen drives, 5 floppies, 13 CDs, 6 SIM cards, 3 mobile phones, and 2 memory cards and 2 digital cameras, etc. were seized at the instance of one of the accused. These were sent to the Central Forensic Sciences Laboratory, which is known as CFSL, not the light, but the Central Forensic Sciences Laboratory, Hyderabad, which prepared a report after examination in 2010. The trial court in 2017 refused to accept the CFSL report of 2010 by citing that the absence of 65B certificate. The stand of the prosecution was that the certificate was not necessary as the original devices themselves were produced as the primary evidence. Still, as a matter of evident caution, the prosecution sought to recall the Assistant Government Examiner, the Computer Forensic Division, CFSL, to produce the 65B certificate in 2018. The trial court rejected the recall application and the High Court later upheld the rejection. The Supreme Court disapproved of the approach taken by the trial court and the High Court. The courts below had gone on a wrong premise to opine that there was a delay of 6 years in producing the certificate, whereas there was none. The court said, pointing out that the CFSL report was on record since 2012 and the necessity of the certificate arose only after the objection was taken by the defense when the examination happened in 2017. From the aforesaid facts, it cannot be inferred that there was a delay of 6 years in producing the certificate. In fact, the report received from CFSL Hyderabad on the basis of the contents of the electronic devices dated 29/11/2010 was already placed before the trial court on 16 October 2012. In fact, the stand of the prosecution was that when the original electronic devices were already produced and marked as MOS, there was no need to produce the certificate under Section 65B of the Act. Still, a matter of abundant caution, the same was produced, that too immediately after the objection was raised by the accused against the production of CFSL report prepared on the basis of the electronic devices seized. The court observed that underscoring the offence was something which shocked the whole nation. The judgment, authored by Justice Bindal, further observed, fair trial in a criminal case does not mean that it should be fair to one of the parties. Rather, the object is that no guilty should go scot-free and no innocent should be punished. A certificate under Section 65B of the Act, which is sought to be produced by the prosecution, is not an evidence which has been created now. It is a meeting the requirement of the law to prove a report on record. By permitting the prosecution to produce the certificate under Section 65B of the Act at this stage will not result in any irreversible prejudice to the accused. The accused will have full opportunity to rebut the evidence led by the prosecution. Thus, the appeal was allowed, permitting the prosecution to recall the witness under Section 311 CRPC to produce the 65B certificate. So, to watch such type of videos, stay connected with us, and I hope you will share this video with all of your friends and contacts. And we have a subscriber base of around 2000, which my dream is to make it to 2000. So it all depends on you, that how you share this video, and empower the other citizens. So stay tuned to our channel for more updates on legal matters that affect you. If you find this video informative, please like, share, and subscribe for more engaging content on legal issues. See you again in the next video with a new topic. Till then, take care, stay blessed, be safe, and remain healthy.